Well, friends, very good evening. Back to part 2 of the Depositories Act. I will tell you about the basic structure of the Act now. Friends, this is the legislation is divided into 31 sections under 6 chapters, and the schedule was repealed now. Significant changes were brought into this Act by Depositories Related Law Amendment Act 1977, the Securities Law Second Amendment Act 99, and the Securities Laws Amendment Act 2004. Then, friends, briefly about the structure. Chapter 1. In general, you had to prepare about the legislation. What I gave introduction, you had to write in 25 marks question. Followed by the structure of the Act. What I am telling you, you have to write. This Act deals with, under Chapter 1, the preliminary provisions like short title and then definitions under sections 1 and 2. Chapter 2 contains the provisions relating to issue of certificate of commencement of business to depositories under section 3. I have told you that's the reason why depositories and participants. Chapter 3 under section 4 to 17 contain the provisions relating to the rights and obligations of depositories, participants, issuer, and beneficial owners. Chapter 4 contains the provisions under sections 18 to 19J related to inquiry, inspection, and imposition of penalties by SEBI against the depositories, participants, and others. Chapter 5 contains sections 20 and 21 on offences. Chapter 6 on sections 22 to 31. The miscellaneous provisions like appeals, limitation, repeals. Then, friends, some of the important definitions. Basically, beneficial owner is one under section 2(1) clause A, that as person whose name is recorded as beneficial owner in the depository. So ultimately, it is he who will get full rights, and any inheritance depends upon his will or inheritance by law. Then the second one is the definition of depository. I have already explained, definition is under section 2(1)(e) of the Depositories Act, that it should be necessarily a company registered under the Companies Act. And it has been granted a certificate of registration under section 12(1)(a) of the SEBI Act 1992. This is the most important thing. Apart from this, under section 2, subsection 32, a depository is defined as it is defined in the Depositories Act. So, reference is with regard to Companies Act and this. As I told you, presently in India, there are 2 depositories, NSDL and CDSL, others are participants. Then, friends, the issuer is concerned. Section 2(1)(f) defines issuer as a person making an issue of securities, a company which is issuing, for example. Then the participant is a person under section 2(1)(g) which is registered as participant under section 12(1)(a) of SEBI Act. Then, friends, this is with regard to one important question as the structure and then the history and then the subject matter of depositories. And then now I will tell you about the rights and obligations of depositories, participants, and others, and the penal provisions. One question on the rights and obligations of depositories, participants. So, number 1, what are the rights and obligations of depository and participants? Number 1, certificate for commencement of business. Section 3 of the Depositories Act requires every depository to obtain a certificate of commencement of business from SEBI. And the SEBI must ensure the depository has adequate systems and safeguards to prevent manipulation of records. As I told you, depositories and participants both must be registered with SEBI. Second one, the rights and obligations of depositories and others. Sections 4 to 17 of the Act contain the relevant provisions pertaining to the rights and obligations of depositories and others. Few of them I will deal with it here, rest of them you please download and then study I will give you some basic guidelines in this regard. Like number 1, agreement between depository and participant, DP, and depository. Section 4, it is mandatory that a depository must have an agreement with the participant as its agent. It should be in such form as may be prescribed under the bylaws of the depository. The second provision under Section 5, services of depository. The services are available to any person but only through a participant as it is provided under Section 5. Then third one, the surrender of certificate of security. The holder of security is called the beneficiary owner and the depository is called as a registered owner for the issuer of securities. These are all the two things you must remember. Then under Section 6 of the Act, any person who enters into an agreement with a depository must surrender the certificate he is holding as securities. Then friends, under Section 7, next important right in obligation, the registration of transfer of securities. Section 7 requires the depository to register the transfer of security in the name of the transferee and receipt of such intimation from a participant. This is the most important aspect. So participant is the intermediary and acting as an agent. Then the depository must inform this to the issuer also. Then friends, under Section 8, the options of the holders of securities is stated, and the holders of securities can opt to receive security certificate or hold the securities with the depository. And if he opts for demat, the depository must enter the details in its records. That is dematerialization, demat means. And then it should make necessary entries in the records. Now for listing companies, it is mandatory that one should enter into depository only. Now next, Section 9, the securities are kept in a fungible form. This is the legal authority for that. Then under Section 10, the depositories and the beneficial owners have certain rights, and then the depository shall be deemed to be registered the owner for the purpose of effecting transfer of ownership of security on behalf of a beneficial owner, and it shall not have any voting rights or any other rights in respect of securities. It is the beneficial holder who will have voting rights. The beneficial owner shall be entitled to all the rights and benefits. Then friends, under Section 11, every depository has to maintain a register and index of beneficial owner in the manner prescribed under Sections 150, 151 and 152 of the Companies Act. Please refer to those particular provisions also. Then friends, under Section 12, the beneficial owner can pledge or hypothecate the securities owned by him with the previous approval of the depository, subject to such regulations as per the bylaws. Then under Section 13, the depository and the issuer of securities must furnish to each other the information on the securities so that there won't be any communication gap. Then under Section 14, the beneficial owner can opt to go out of depository in respect of any security and go back to remat, that is rematerialization. However, as I told you, for listed companies, it is compulsory that it should be in demat. Then under 15, the Bankers' Books Evidence Act shall apply in respect of depository as if it were a bank as defined in Section 2 of that particular legislation. Then friends, under Section 16, if any loss is caused to the beneficial owner due to the negligence of the depository or the participant, the depository as the principal has to indemnify such beneficial owner, and then that can be recovered from the participant, that is DP. Now under Section 17, the rights and obligations of the depositories participant shall be specified by the regulations. So this is one essay type question, and these are all the sections which I have already narrated. You download and again note down, and then you make out a notes and then prepare well for the examination. Then friends, in part 3, because this separate question it is in the examination point of view. So part 3, I will come back to you with regard to the penal provisions and then the Securities Appellate Tribunal. With that, we will close down the study of this particular legislation. Thank you.